Well, good evening, everyone. Thank you for coming to our biotech patent law discussion. My name is Julia Dunlap. I'm the Director of Legal Education for UCSD Extension, and part of the legal education classes that we offer, we have an intellectual property certificate. And our three panelists that we have tonight are actually instructors in the intellectual property certificate. We have Bernie Greenspan, first right here. He's a PhD from Prometheus Labs. He's been teaching in the program for a long time. Next to him is Mathu Sharon. She's also a PhD and currently a patent consultant. She's going to be teaching our patent drafting class this spring. And last but not least, we have Mark Morley, who's the partner at Foley and Lardner, and he teaches our biotech patent law. So they're going to be telling you just something about their careers, what they've seen in this field of biotech patent law, and then there's going to be plenty of time for question and answer at the end. So thank you. We'll start with you, Bernie.
Okay, so I'm Bernie Greenspan. I'm the Director of Intellectual Property at Prometheus Laboratories. We're a diagnostics and therapeutics company here in San Diego. We're a subsidiary of Nestle Health Sciences. And I started in my career as a PhD scientist looking at respiratory drug delivery, aerosol physics, and did that for about 20 years. And came to San Diego and worked for what was a startup sort of company called Dura Pharmaceuticals. Was there for a while as director of research and began to take on responsibilities for the intellectual property portfolio, which actually in retrospect turned out to be a fortuitous event, because when the company was acquired by a major pharmaceutical company, they laid us off. And I wanted to stay in San Diego, so I made a career change. This was back in 2001. So I've been doing IP work now for, 13 years full-time. I worked for a number of companies, including Pfizer and some startup companies. I spent a couple of years as an independent consultant, and then went to Prometheus. So in the program, I teach two classes. I teach the Introduction to IP Law, and I teach a patent and IP searching class. So Julia asked if I could explain a little bit about the day-to-day work that I do. So at Prometheus, I am the IP department, and so I'm responsible for managing the patent portfolio. We have approximately 100 active patent families and about over 500 active cases worldwide, patents that we're prosecuting. Most of the prosecution's done by outside counsel, so I manage that activity and set strategy for responding to office actions. But I also am involved in the management of the trademark portfolio, clearance of trademarks, and then Nestle now prosecutes our trademark applications. I review the IP provisions in contracts. We have a lot of collaboration agreements with different companies, and so work with the other attorneys looking at the IP provisions. I provide training for the staff on intellectual property matters, and I also chase around looking for signatures on documents as well. So my day-to-day activity is any and all of those activities kind of all at once. It's exciting, it's always something different. And I've been at Prometheus about 4 years now. Never thought I would be doing diagnostics work, but that's the interesting thing about intellectual property, is you're never really quite sure what area of science is going to come to you. So that's why I like it a lot.
My name is Mathu Sharon. I'm an independent patent consultant. What that means is I have clients that range from inventors with one small idea to some small companies that are already set up and have funding. I help them from doing patent searches to helping them write their patents and prosecute them, helping them with their IP strategy. So my focus is consulting with small companies, independent inventors, and helping them set out a strategy so that they can either go forward with their invention, go forward with their company's strategy, or make decisions accordingly. I got my PhD from UCLA in microbiology, and much like you attending a panel, I was pretty sure I didn't want to continue doing research, and so I was looking for ways to utilize my PhD, but not in the lab setting. And there was somebody on the panel who had gone to a law firm and had entered the patent field, and he seemed very happy, and I had a million questions for him, and so that kind of set me on a path to becoming a registered patent agent. And from there, I worked at a small biotech company in the LA area in their IP department. My next experience has actually kind of launched me into sort of the small inventors and small company world. I was at a company in Florida called XL Tech Group, and their business model was to evaluate technologies, evaluate IP portfolios, and launch companies from that. So it was a business development company. And my experience there, I was IP manager, and I was the only IP person in that company. And what I did was everything. We wrote patents, we managed outside counsel. I was in charge of doing all of the evaluation, so looking at patent portfolios of companies or technologies we were thinking about acquiring, figuring out, is it going to be a good investment? Is it something we should pass on? And we spun out companies, and when the company got spun out, in the initial stages, I was in charge of setting their IP strategy portfolio. So expanding their IP, expanding their trademarks, copyrights, anything that was appropriate, and setting the course for that company. And then within a couple of years of doing that for that spin-out company, they would acquire their own outside counsel. I've also worked at a law firm and gotten a lot of experience writing patents and provisionals and responding to office actions. And from there, that's when I started to decide to launch my own consulting group. The network of people I know have all landed at other different companies. I get work from referrals, past clients, and it is exciting. I get to do sort of a lot of different things. It's not just microbiology, that was my background, but I've had projects that are in nutraceuticals, veterinary science, energy. I've had a lot of clients in the energy sector, so algae to biofuel, other sort of new biofuels and new energy sources. That's been kind of a hot topic. And so what I find exciting is that with a science background and a science understanding, you can really pivot yourself to be involved in a lot of different fields and a lot of different things. You can get a lot of excitement from seeing sort of the new inventions and new ideas that are out there, and then you're part of. You don't have to be an expert in pharmaceuticals, but you'll get pharmaceutical projects come your way. You don't have to be an expert in energy, but you'll have enough knowledge that you can write patents and help with the IP strategy. So that's what I find exciting about biotech field.
Well, my name again is Mark Morley. I'm a partner with Foley & Lardner, which is a national or international law firm located here in San Diego. I came out of undergrad with a degree in microbiology and immediately went up to the Bay Area and started working for a couple of different biotech companies for several years. Ultimately, working in those small companies and seeing the value of intellectual property and patents and trademarks, I thought that looked like an exciting career. And I chose to leave the field and go to law school for 3 years. And that was in the mid-1990s. Went to law school. At the time of completing law school, I decided San Diego seemed like a pretty great place to be. A lot of opportunities in biotechnology, exciting companies and research institutions here. So moved down here, I guess about 13, 14 years ago, and joined a law firm as a junior associate, working my way up the ranks there, doing primarily biotechnology patent work. Actually met Mathu while there many years ago. It's a very small community of professionals. And so I've been practicing as an intellectual property patent attorney since 2000 here in San Diego. And now I'm a partner at the law firm where I practice. And my day-to-day is working with clients of all shapes and sizes, helping them with their intellectual property strategy. And that could be building their intellectual property, taking their technology and figuring out a way to protect it, help them guide their intellectual property strategy in that way. It could be, we've got a technology and we might be stepping on the intellectual property rights of somebody else. What do we do? a lot of that kind of work where we're giving opinions and advising on how to stay out of trouble from the intellectual property standpoint. Do a lot of trademark work as well for life science companies, probably somewhat similar to what Bernie does, where you're trying to come up with a brand or a product name for a soon-to-be medication or medical device. I work on that type of work as well. And from a technology standpoint, one thing I really love about intellectual property is I worked, as I noted, doing microbiology type work. I babysat E. coli, growing recombinant protein products all day, all night long. And I love what I do now because I see everything. Everything from stem cells to recombinant protein molecules to small molecule pharmaceuticals, immunology, fuel technologies. You get to see really a wide range of technology, which is pretty exciting and a lot of fun to do. And at the stage I'm at now, I get to see I branch outside of classic life sciences and do some high-tech work and software and other interesting things, it's a fun profession to be able to constantly be learning new things and getting exposed to interesting people that are excited about technologies rather than I don't want to sound pessimistic, but the same failed experiment that I had for several years when I was in the lab that was great, but it's fun to see new things and to see the success stories that come out of it. So that's what I do on a day-to-day basis. I've taught here I think I just completed my 5th or 6th year here. I'm also a professor of patent law at the University of San Diego. I've been doing that for 6 or 7 years as well. So I enjoy getting out and meeting people in the community as well. It's a great community, and I've known Bernie for quite a few years as well, and we all bump into each other here and there. So there's a good camaraderie and a great profession in that sense.
Bernie, would you be able to give just an overview of what intellectual property law is for those in the audience?
This is the quiz portion of the talk. So an overview of what intellectual property law is, yikes. So intellectual property law comprises patents, trademarks, copyrights, trade secrets. So there's 4 basic categories. Patents protect inventions, the function of an invention or the steps of a method. They give you the right to exclude other people from performing that invention. There's a category of patents called design patents that protect the appearance of your product. If you've been following some of the recent cell phone disputes, the rounded corners and the button at the bottom look of a very popular tablet is the subject of a design patent. Trademarks, people think trademarks protect companies and brands, but actually trademarks are designed to protect the consumer from becoming confused about the source of a product. So the trademark identifies who the source of the product is, but from a company point of view, we use them to identify the brand of our product. Copyrights protect original works of expression. And so, although we're not in the business of creating artwork and sculptures and music, we do sometimes put artwork on our products, or we write procedures that can be copyrighted or instructions. So we use copyrights to protect that. And trade secrets, a very important component. If we have information that gives us economic value from being kept secret, then we can derive protection under the law. And if people misappropriate that trade secret, and we can show that we took steps to protect it, then we can go after them and prosecute them for that. So hopefully I passed the quiz.
And so where does biotech patent law fit in to the overall scheme? What's the difference, or how would we define biotech patent?
Well, the way that I characterize it in the course that I teach is because of the inherent unpredictability of the life sciences, you get a body of law that has some differences, some distinctions based upon that unpredictability, where it's hard to know exactly how things will react. Similar molecules can have completely different results or activities if you were to administer them to a person. And so a lot of the case law and the things we study in biotech patent law are based around the unique parts of the case law and the law of intellectual property and patent law by and large that are driven by the unique aspects of biotechnology and chemistry, and those are things you don't see with a mechanical device. You can very well predict how that device will react and what will happen when you put those things together, whereas you don't always know what will happen when you modify a cell line or when you administer a protein to a patient or a subject. They can fold differently. There's lots of different things that make it unpredictable, and so there's an interesting law that is built up around biotechnology because of that, those distinctions in the science.
Mathu, do you have anything to add to that?
Well, further to that, I think the unpredictability, but also biotechnology in general has sort of really flourished in the last 10, 15, 20 years. And so because of that, the law has sort of had to catch up. Before, patents might have been directed to pharmaceutical drugs or a chair or a table or the design of a lamp, let's say. I don't want to make it too simplistic, but in the last 15 to 20 years, we have gene therapy, we have stem cells, we have things that are, not as easily defined inventions, and then therefore the law has a hard time, evaluating that. The way you can protect a simple invention like a chair or a table, that's not going to really apply to biotechnology. How do we define a gene? Can we patent a gene? That has been a really huge question. Initially with the law, if it was man-made, that's the real criteria. It has to be something man-made, not occurring in nature. And so, biotechnology allows us to make a copy of DNA. Well, that's technically man-made, so we can patent it. But there's a lot of cases around the fact that, but that occurs in nature, so is that really fair for a company to be able to patent a gene? So that's a very unique situation. That's not something that would have been foreseen when patent law, originally the concept of patents and patent law. So I think that's what it really covers, is the fact that there's this flourish of inventions and concepts that really have only occurred in the last 15 to 20 years, and the biotech patent law really covers those unique situations.
It's a good point, because even when I started teaching here 5 or 6 years ago, we would talk about what is eligible for patent protection in the life sciences, and we'd kind of say, move along, people, not a whole lot to worry about here. It's pretty well settled. And as Bernie and his company know, and the breast cancer gene, Myriad, there's been a huge change in the world of what's eligible for patent protection. So there's a lot that happens because there's a lot going on and a constant evolution in the law.
So in some ways that's what makes it exciting, but also kind of scary. So the company I work for is one of the parties in a very well-known case around naturally occurring entities. And so we strive to find ways to overcome the court decisions. Being in a diagnostics company, we're dealing with nature, the body. It's hard to say that things are not naturally occurring, and yet we look for ways to achieve protection for the discoveries that we have, because we develop tests that allow us to analyze a sample of blood or tissue from a patient and then either come up with an accurate diagnosis or an accurate prognosis of their disease, and in a much less invasive way than would normally be done.
Do we have questions from the audience?
Okay, so the question was if we have any projections or for job growth in IP, patent attorney jobs. I can tell you that amongst the colleagues that I have at biotech companies, there are many, many companies that have no one in-house paying attention to their IP portfolios. That's what brought me to virtually every company I worked for. And so I see huge potential for people that can take their scientific background, business understanding, and understanding of IP law to a company and say, I know how to help you organize your portfolio, pay attention to it, and grow the portfolio.
I can probably say that when I graduated from graduate school, it was just the beginning of the biotech bubble bursting and more interest in software and things like that. That didn't really dissuade me or discourage me, because I figured, things sort of have a cycle, and if you can get the work experience in the area that you want, if you just get that first kind of break, then you get to, and you utilize your first experience to get as much experience and skill set as you can, then things sort of roll into the next thing. And as Mark said, it's a small enough community that you can really tap your resources and tap your network once that's established. So we're right now probably experiencing, if you look in the job market, a lot of opportunities for people with electrical engineering degrees. Now, does that mean you should run out and get one? If you're interested, yes. But probably by the time you're done, the cycle will have changed and become something else. So I'm a big believer in figuring out what it is that you like to do. Try to get your first, experience, your foot in the door. Somebody really gave me a chance. I had no experience. I had become a registered agent, took the exam, but I had no experience. And I, through a friend of mine and a referral, I got introduced to the IP director at a pharmaceutical biotech company in LA. That's how I met Mark. He was the outside counsel, him and along with another colleague of his. And that just sort of snowballed into other experiences and a variety of experiences. So at that time, sort of the biotech bubble was sort of on the downhill, and now it's sort of coming back, a lot of interest and a lot of growth. But I would say sort of find out what you're interested in doing and pursue that, and just sort of put your nose to the grindstone about getting that first experience, because whatever field, that first job, that first experience is really the hardest to get. But once that happens, then you start to build on your career from there.
Yeah, and I think I agree with that. There's two general entry points, in my view, to the profession. There's the patent agent entry point, where you're a non-lawyer, but you have a science background and you qualify to practice patents by taking the patent bar, which is a separate bar exam that anybody with the requisite technical background can take. And so Mathu and Dr. Greenspan are both patent agents. They didn't sell their souls and go to law school like I did, but they entered through that. And there's my firm, for example, we have quite a few patent agents that work there. They do the same work, a lot of the same work that I do, and that's one way to get into the industry. The other way is as an attorney. You go to law school and you go through the process of getting a job through law school hiring. And there's pros and cons and differences of both of those. And but I think there's still a good opportunity. The tough part is often that first one, as there is with everything. But I think if you have a passion for it and you really want to do it, and if you can be a little bit geographically flexible, you can get that first opportunity and ultimately end up where you want to be. But sometimes you have to be flexible. I started in the Bay Area. I worked in Washington, D.C., knowing that full well I wanted to ultimately be somewhere here near San Diego. And it took a few years, but in the end it worked out. So there are good opportunities if you really want to push for it. Mm-hmm. That's a good question. You want to take it, or you?
The questioner said that she has a bachelor's degree in biology and is going to law school now, and was wondering if a career in IP law would be inhibited in some way with only a bachelor's degree as opposed to a master's or a PhD. I think I got the question right. So I know that some large pharmaceutical companies make a point of only hiring master's or PhD patent attorneys. However, I don't think that that's the general rule. The baseline requirement for passing the patent bar is a bachelor's degree. And like any field that you go into, even if you had your PhD, that science would only be good for a few years. In fact, now 6 months maybe in some fields, right? And so you'll have to keep up and study. So I would say it's only as good as your ability to learn new science. if you come out with a strong grasp of the law and an ability to understand and take on new science, I don't think you'll necessarily be limited. I really don't.
I would probably add to that you're going to find instances where there are job openings that do say, PhD minimum. Having a PhD but not having a JD, I find also job openings for must have a JD, even if you have a PhD. So you're going to run into that, but I would say if you are going to law school, I think the skill set is the biggest thing that you can sell. So if you have a science background and a bachelor's in science, if you're going to law school, if there are unique skill sets that you can get through internships or experience, I think that's the thing to focus on. Maybe it's IP plus you are really great at business transaction law, or something along those lines where you build up a cachet of skill sets and that's what you advertise, not just, you can apply for those jobs that say master's required, but possibly JD preferred, that type of thing. There's going to be jobs like that, but there's also going to be others where people are not interested in so much the degrees that you have as much as the experience that you have and the skill set that you can advertise.
And I'll add one thing to that, because I'm you, probably not as smart as you though. There is a bias, and not necessarily, and I think it's just a part of the industry, frankly. Does that mean you can't do it? No, it just means you're competing against, depending on the type of position, you're going to be competing against people with PhDs and postdocs. And so I think that is a reality, that it makes it a little tougher. And so what I tell people is it's a balancing act, depending on where you're going to law school. If you're going to the world's #1 ranked law school with a bachelor's degree, you're going to be fine. If you're going to a law school that maybe isn't quite as highly regarded, then the competition's going to be tougher. And frankly, here in San Diego for that first job, that entry-level job, you're competing against people from all around the country who want to get out of Chicago in the winter and be here working in patent law a mile from the beach. So in reality, it is a little bit of a tougher road to climb. There are some biases out there. But again, if you're a good writer, a good communicator, a hard worker, and you have a good background, you can do it. It's just a little bit of a higher hurdle to get that first position, in my frank opinion.
I want to add one more thing too, because I think we all sort of gave an answer from the point of view of patent law, and because I think you mentioned the science degree, but there are other aspects of IP law, right? There's trademark law, there's litigation, and you don't need to pass the patent bar to do IP litigation or IP transactional law or mergers and acquisitions or trademark law. So you would open up, by being in law school, a broader base as an attorney than someone like me who's a patent agent, because I cannot file trademark registrations for people other than my own company if I choose to do that. Only a licensed attorney can do that. So the bachelor's degree in science may not inhibit anything at all, because you'll be opening up a different career path. And I think that may apply to other people in the room as well, to think about that.
Yeah, that's a good point. Litigation, other types, they're not going to have that same bias as the people that are on the prosecution side. So it helps.
Well, I'll tell you one thing, that when my boss in 2001 told me I was now in charge of the IP portfolio at Dura Pharmaceuticals, I had only been on the inventor side, and said, well, I really need to take this seriously. I have to find some resource. And so it was before the IP certificate, but I took every class that the extension had to offer in IP law. And were it not for that, I don't know how I would have managed to do it. So it was very, very valuable. I think the certificate is a way, the IP certificate is a way for people to demonstrate to others that they've completed a core set of classes and have a basic grasp of IP law. It's not going to get you to pass the patent bar. It's not designed for that. But it will give you some real life skills that you can put to use right away if you were put in an IP liaison position or something like that. As far as the paralegal certificate goes, when I go to finally get to hire a paralegal in my position, it will only be someone with a paralegal certificate. I think that's paramount importance if that's the career path that you're following. I really see it that way.
I would just add one thing, and that is that the quality of instructor, I mean, the diversity that you get, I think I'm very impressed. And the quality of students in the classes that I've taught, that's probably one of the real unspoken benefits is the networking and the getting to meet a lot of other people that are in that industry. And so I run into people all the time that talk about Bernie and what a great job he did as their instructor.
And you as well.
Yeah, and they know that they can call him if they need a reference or advice. And so there's some real value there, just intangible value to it that way. So the question is, can we recommend any materials or tips for preparing for the patent bar exam? So I don't know if you guys want to.
I can say what I did, which was probably, at the time, not really the normal course of things. A lot of people at that time worked at a law firm as a technical specialist. I don't see as many job openings for that. That was sort of a position in the early 2000s that somebody with a PhD could work at the law firm. They sort of did all the literature searching and review, and it was sort of a stepping stone to take the patent bar exam at the law firm while they were at the law firm, and then go on to be a patent agent or go to law school and become a patent attorney. I was pretty eager to get out of science, so I thought, okay, I'm going to focus and get this registration, and maybe that'll help me get that first job, because I sort of knew the biotech bubble was bursting a little bit. I just took a course. There's like 2 major groups that offer courses, and studied for it on my own. At that time, I think it was still an open book exam. Maybe now they have it online or something. I think at that time the tip that they said was really just know the patent manual really well and where to go. Don't try to memorize everything. But without going in detail about that, I would just say if you have the means to take a course, whether that format is best for you to be at a live course or an online course, I think that really helped me with the actual exam, because the exam itself, besides dates and things like that, on your day-to-day, you're not really utilizing it. The patent bar is designed for patent examiners to pass, so that they're examiners, but the patent agent also has to take it, or a patent attorney has to take it, so that they understand and are capable of prosecuting patents for patent applications for inventors and companies in front of the U.S. Patent Office. So sort of on a day-to-day, I'm not always referring to all the material that you get used to. Okay, certain dates, 1 year something expires, or you have this many days to respond to an office action. That becomes part of your daily routine. You don't have to really look at that book. So really the studying is for passing it and your experience. Once you pass it, what I realized was it doesn't mean anything. It's all the experience that you get afterwards, writing office actions to the patent office, writing applications. So if you view it as just a stepping stone to getting a registration, whatever you would do to pass the driver's license or pass an exam, that's what you should do. Because after that, that's really not going to qualify you to write a patent. You are allowed to, but you will be just like anybody else, not really have very much experience. So it's that first job, that first experience that gives you the skill set, kind of what order to do things. I think the certificate helps without passing the bar. I think the certificate allows you an introduction to the patent field that will help particular people. Sometimes it's being a liaison within your own company. Sometimes it's exploring this field to figure out, is this something I want to go into? The UCSD extension courses, I think it really fits whatever you want to take out of it. But passing the patent bar, I think committing to doing that, you really should know whether that's the field you want to get into. And then from there, that's a stepping stone to getting that first job. You are registered. You might not have experience yet, but you're looking for your first job to get experience. I think a lot of people do go to law school first, and then once they leave law school, that's when they take the patent bar. So The patent bar really is just when you're trying to decide when you're having your first job. In my case, I did it right after, at the end of my graduate career. I could have gone to a law firm and been sort of on the periphery of doing things and then taken the patent bar exam. And then when you take the patent bar exam, you're qualified to write patents for someone else. If you don't have that, you're not qualified to write patents for someone else.
Yeah. I think it's important to take some IP courses first. And as a scientist, it took me quite a while to learn to read the law, because the law has its own vocabulary, the case law has its own way of explaining things, and it's very, very different than science. You know, you don't wake up one day and find out that everything you knew about science is now totally upside down. But the Supreme Court can issue a decision and you could wake up and say, everything I've done for the past 5 years is now wrong. and you have to be able to read the decision and understand that. And for some people, that's difficult. It was very difficult for me at first. And so I've sort of traded off kind of studying the science and learning to read and understand the law. So what Mathu said is it's very important. Is this something you want to do? It's more than just escaping from the laboratory, because you need to know what you're escaping into. And there's a lot of effort and time to pass the patent bar. So you might want to think about it.
So to restate the question, if I'll try, is do the courses in the biotech courses at the extension, will you pick up some of the terminology, the vocabulary, the lingo that will be helpful to transitioning into doing kind of biotech type legal work, maybe on the contract side, or is that a fair restatement?
Or go the patent paralegal route or whatever.
And do biotech patent paralegal work. The course I teach, which is the Biotech Patent Law course, number one, I teach it like a law course. We study case law. We go, and the case law is full of science. And so, and I have usually, 10 or 20% of the students are non-scientific paralegals, administrative folks that work at law firms or at companies that want to get that background. And we try to help those people get some basis learning some of the big concepts that are out there in biotechnology, some of the key areas of that law. That's not the focus, but I think you get some of that, at least in the course that I teach. You will pick up on some of the key areas of the science, and it'll help you in that way.
I would say I review a lot of contracts working with the other attorneys at our company. And I think what's important as a foundation is to understand how the IP works, and then then you can understand what the contract language is all about. And so whether it's specifically a course in IP contract law, I think a lot of the lessons from the cases, many of the cases anyway, show clear steps that companies could have taken in hindsight to avoid some of the problems that brought them to the disputes. Certainly in trademark and copyright law, you see that a lot, very often in patent law, when, at least if you're not looking at a simple infringement kind of an issue. I think the fundamental understanding of how the IP underpinnings work helps understand how to draft a better contract.
It's a great question. Whether we would describe ourselves as having business acumen, or if it's required, or those things. I know this is something that I think Bernie probably has some feelings on.
Well, okay. Yeah, I don't know if I have business acumen or not. I certainly insert myself in a number of situations to just try to bring the IP perspective to it. So over the years, I think I've acquired an appreciation for the goals of the company in moving a product from discovery through to the marketplace. And I can't sit down and calculate the net present value of the dollars, but I know that the accountants do it, and I understand what the model is. I'm always called upon to give scenarios of pessimistic base and optimistic length of exclusivity for a product, because the business people will put those time periods into their model to decide what the return on the investment might be. And so I need to understand what they're going to do with the information I give them. Otherwise, they'll come back and say, but you told me that, you know, we'd have this product on the market for 20 years or something like that. And we only had it on for 2 years, and then they're very upset. So you need to have an appreciation for what the rest of the business is doing, because IP touches many aspects of it. It touches marketing with the branding. It touches product development and research with patents, and you know, and as well as contract negotiations or diligence on companies you want to acquire. I think over time, though, you begin to acquire that appreciation, rather than, say, charge off to business school and get an MBA on top of a law degree and on top of a science degree and things like that.
I don't think you have to be a business whiz, but there are positions at law firms that all you're doing is writing patents and prosecuting patents. There's a role for attorneys and some agents, whether it's in a company or at a law firm, to help set the IP strategy. And I think that's where the business acumen, whether it's acquired, whether you kind of naturally have that, you know, intuition, to just see that you're not just writing a document that covers a certain invention, you're trying to help that company or that inventor think long term. What are the things in 5 or 10 years that might, you know, be important, where this product could be improved upon, and you want your inventor or company to capture that right from the beginning. You know, my experience came from sort of not the legal side, but the business side. Right very early on, I worked for a company that was reviewing technologies, reviewing IP portfolios, and then spinning out companies. So we had to look at things from the perspective of IP, from technical competition, and from marketing. Was there a market for this product or this service? Was the IP actually covering that? Could it be expanded? And then we'd spin out a company. So I think I got a lot of business experience from that. That's not necessarily required to do IP, but it's what makes it interesting to me, to be able to go in and say to an inventor, you know, there's a bunch of other things that are very similar to this, why don't you go in a different direction? Or to tell a company, you know, yes, you can get a patent on this, but maybe you should think about things a little bit more outside the box and help them with their strategy, so that they're seeing things 5 to 10 years down the line. Some people, they just want a patent on this one thing because it's a very crowded space, and, you know, if you're really great at drafting patents, then you can help them get those claims and charge forward, because that's really important to them at that moment. So I don't think you need to get an MBA for all that. I don't think an MBA may even help you with getting that kind of business acumen. I think, again, it goes back to sort of experience. If that's the arena you want to go into, if you work, I think you get that when you work inside a company. If you work at a law firm, you know, I think attorneys acquire that from having different clients and helping them. But I don't think it's a prerequisite of saying, you know, I know how to do business financial models or anything like that. I think it's something you acquire. It can be something that you want to acquire. You can do it, or you can just kind of draft patents or work for the patent office and sort of review patents. So I don't know if that helps answer, but
yeah, no, I think that's law firms. It's you don't have a lot that have their business acumen always, but you can succeed in the law firm setting if you're really good at writing patents, as Mathu pointed out. We'll never put you in front of any person. You just write patents and do a great job. You can do really well. If you have that business acumen, it can really help you in the long run, just to add more value to what the clients need and to move up the ranks, so to speak, if you have that. So the question is whether the business environment in San Diego, if we've got regulatory environment, if it's drawing companies in, if Rick Perry's drawing them off to Texas or wherever. I would say my experience is things are better today than they were a year ago or 2 years ago. There seems to be more investment money coming in, more companies that are starting to start up again, which is good, because San Diego, in my view, for a long time has been a startup mecca, a startup hub with all the UC and Scripps and Salk technology. So it's getting better. You know, but we do have that competition from states like Texas and others that are doing everything they can to become like California, like San Diego was over the last 10, 20 years.
Yeah, I don't know if I have my finger on the pulse of that anymore, but earlier someone had said that you need to maintain some geographic flexibility, and I don't know that it'd be that much easier to get a job in Texas or one of these other places drawing companies away, but I don't think you should rule that out as a possibility for that entry position that Mathu said is so important. The first opportunity is really kind of the springboard, I think.
I would agree. I'm not sure what the pulse is exactly. I have noticed that in the last 6 months there have been a lot of more job postings, both locally and nationally, for biotech patent positions, people with chemistry, biology background. Over the last year and a half, there's definitely been a plethora of opportunity for people with electrical engineering degrees. I don't know that that's just focused in San Diego or not. I think that's kind of the pulse nationally. And I also have sort of noticed that, after the kind of 2008 little kind of crash, depression, whatever anybody else wanted to call it, it took about 2 years for things to catch up with the IP group. And I think the reason for that is big companies had already set their IP strategy. They already laid out money for the patents that they were going to prosecute. And so in 2008, when there was a lot of economic downturn, I think I was at a law firm, IP attorneys were a little bit insulated, and then it caught up 2 years later when companies had already decided, okay, we're going to shrink our budget. There's a lot of creativity as far as they weren't going to pay those crazy hourly rates anymore. They wanted to negotiate different flat fee rates with attorneys and law firms and cut their IP costs, because the company as a whole had to start cutting and trimming costs. But now I think it's kind of come back where, okay, we need to expand our IP portfolios. Small startups, I think, regardless, had to pay sort of if we want to do this business, we have to be all in. And so they would be hiring even throughout those times. But I think geographic flexibility is really important, as has been said by the panel. Look everywhere. If you have to just stay in San Diego, for whatever family reasons, personal reasons, that's one thing. But if you have that flexibility, look nationally, because there are other hubs like Boston. I know that Florida is trying to expand its biotech and med tech focus. So if you have flexibility, look in other areas, because regardless of where you're located, more often than not, the company is going to have sort of a national footprint or a national presence.
And if I could add one other flexibility thing or expanded concept, do not be just a biotech person. I had a person come to me a few years ago from a top-notch law school, and I said, well, are you comfortable doing molecular biology? Yep, I love molecular biology, especially on the malarial genome. I know it, and I really want to do patent work on the malarial genome. Well, are you comfortable with biochemistry? Or what about small molecule chemistry? And the person just kind of talked herself right out of a position when I wanted them to just say yes, and they're in. And all of you I know will probably say, well, I'm a molecular biologist and that's me. But believe me, a bachelor's in microbiology can do a fair amount of chemistry. So characterize yourselves, your capabilities, and your willingness to do work as broadly as you can, and it'll open up more doors. Because frankly, in my view, chemistry, the more you can characterize yourself as having chemical skills, the more opportunities you'll have.
And you don't have to do the experiments. I mean, they're not going to quiz you on, how their stuff works, or they repeat their, that's, I think, as a scientist, you think, oh, well, I can't qualify myself as a chemist. What if they start asking me all that? You took chemistry classes. If you're in molecular biology, what you're doing involves chemistry. It's the ability to read and understand the terminology and the concepts that are part of a chemical patent or a pharmaceutical patent. And if you are a decent scientist, then you can read on any topic and understand it. And that's really probably where you wanted that potential candidate to say is like, yeah, I can pick that up, that's not a problem, and have confidence that you can do that. Because I think that's kind of a preconceived thing, is that, oh, my degree's in microbiology, I don't want to say that I can do all these other, you just need to be able to read about it and write something up on it. You don't have to do the experiment.
Yeah, when I left my science job in aerosol science and respiratory drug delivery, I went across the street to Pfizer and was involved in ophthalmology, oncology, virology, everything but respiratory drug delivery. And it was scary and exciting at the same time. But again, I wasn't the one having to do the experiments or discover the molecules or anything like that. It was just the scientists come to you with the molecule. The scientist comes to you with the method of synthesis. And it's the patent person's job to understand how to translate that into a patent application, and also how to talk to them about, well, yeah, you have this method, but what other methods do you have, and how can we, get the broadest description of it, and you show them how to put their invention into a patent, but you don't have to make their invention. They made the invention, and at first they may feel kind of sad, like, oh, I want to be inventing it, but that's the trade-off, right? You've given up that part to sort of help others realize the value of what they've created. And it's a lot of fun.
Well, thank you all. Appreciate it.